When emotion becomes a crime, California's rule.
A spouse discovers an affair. A parent finds someone hurting their child. A person endures years of abuse until they finally snap. These kinds of moments can turn ordinary people into defendants facing up to 11 years in prison for voluntary manslaughter. Today, I want to walk you through how California law treats killings committed in the heat of passion and why these cases are handled differently from murder. Voluntary manslaughter is one of those charges that sits in a middle ground. It's still a serious felony, but the law recognizes that overwhelming emotions can drive people to make tragic decisions they might never have made otherwise. California Penal Code Section 192A defines voluntary manslaughter as a killing that happens upon a sudden quarrel or heat of passion. The difference between this and murder is malice. Murder requires what's called malice aforethought, which means a deliberate decision to kill with either express or implied intent. Voluntary manslaughter, on the other hand, acknowledges that sometimes intense provocation can cause even reasonable people to lose control. So what exactly does heat of passion mean under the law? It refers to powerful emotions like rage, fear, or jealousy. Emotions so intense that they cloud judgment and drive rash actions. A sudden quarrel is just what it sounds like. An unexpected confrontation that explodes without warning. But there's an important requirement here, Shah. The provocation has to be serious enough that an ordinary person of average disposition would lose self-control. And there cannot be a cooling off period. If someone had time to calm down, the law no longer treats it as heat of passion. For prosecutors to secure a conviction, they need to prove several elements. They have to show that the defendant intentionally killed someone, that it happened in the heat of passion or during a sudden quarrel, that the defendant was provoked, that the provocation would have caused a reasonable person to act rashly, and that there wasn't time for the defendant to cool off. In a way, these elements actually help the defense. They provide a path for reducing a murder charge down to manslaughter when the circumstances fit. Not every type of provocation qualifies. Words alone usually aren't enough, no matter how harsh. The law looks for something more concrete and extreme. Classic examples include catching a spouse in the act of adultery, seeing a child being molested, being physically attacked, or enduring extreme acts of domestic violence. The question is always the same. Would this situation cause an ordinary person to act impulsively without thinking things through? The penalties are severe, but they are much lighter than for murder. Voluntary manslaughter carries 3, 6, or 11 years in state prison, plus fines of up to $10,000. It's also a strike under California's 3 strikes law, meaning it can have serious consequences if there are future convictions. And like other felonies of this nature, a conviction means losing the right to own firearms. But when you compare that to murder, which can carry life sentences, voluntary manslaughter reflects the law's recognition of human frailty. There's also an important doctrine called imperfect self-defense. This applies when someone honestly believes they need to kill to protect themselves, but that belief is unreasonable under the circumstances. If the jury finds that the belief was genuine, even if mistaken, the law reduces the crime from murder to voluntary manslaughter. This doctrine can make the difference between a sentence that lasts for life and one that, while still serious, acknowledges the defendant's state of mind. Real-world cases help make sense of this. Imagine someone walking in and discovering their spouse in the middle of an affair. They immediately lash out, and it results in death. That's the classic heat of passion scenario. Or consider a bar fight where a punch is thrown. The victim falls, hits their head, and dies. What started as a sudden quarrel becomes voluntary manslaughter. Or think of a long-term abuse victim who finally retaliates during a moment when their life isn't directly in danger. These cases show how ordinary people, under extraordinary circumstances, can end up facing charges that carry life-altering consequences. Voluntary manslaughter cases are complex, personal, and emotionally charged. The law tries to balance accountability with an understanding that extreme emotions can push people past their breaking point. But no matter the circumstances, the stakes are high, and having a strong defense strategy in place is critical. If you or someone you care about is facing voluntary manslaughter charges, schedule a consultation today. The sooner you act, the more options you have to protect your rights, challenge the evidence, and fight for your future.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.